Good afternoon. My name is Jessica Arendt. I'm well known as the hemp enchantress throughout this industry. I've been in the industry since 2015. I came from the tequila industry, ironically. I specialize in compliance and regulatory practices, both here in the United States and around the world. And I have been a moderator here for the CBD Expo now for the entirety of this season, and we'll close it out at the end of the year. My company is BH Private Label. I handle human resources there. I'm also a compliance officer for a little bitty brand that's organic called Cannabidiol. I'm going to allow each of our panelists today to take a couple of minutes to introduce themselves and give you a little bit of a background on their industry experience and what they're doing here today. And then after that, we're going to jump into a series of questions and address the topic. So without further ado, we'll just start with Jim and take it from there.
Hello, everybody. I'm Jim Thorburn. I'm a local attorney here in Denver. And the way that I got involved in cannabis and CBD is that I started out in the tax area, mainly Section 280E. Now, CBD is not so, 280E is not so applicable to 280E, but but definitely cannabis is. And where 280E is the bane of the cannabis industry, where the IRS tries to tax you effectively about $1.20 for every dollar you make. And so that's how I got started. And there's been a lot of court cases on that, and you've seen my name on a lot of those court cases. And so it's just that started about 10 years ago for me. And with that, I've kind of morphed into various areas, including CBDs and all. And so here I am talking to you. Welcome, and I look forward to speaking.
Hi, everyone. I'm Kyle Ray. I'm one of the original owners and founders of Colorado Chromatography. We specialize in the large-scale manufacturing of rare minor cannabinoids such as CBN, CBC, THCV, CBG, CBDQ, and some other letters I'm sure that you guys probably haven't heard of. And you know, my real experience within this industry is kind of creating a lab from inception all the way up to a fully functioning and production facility. So yeah, I have a lot of experience dealing with local municipalities, the Colorado Department of Public Health, fire departments, all the fun stuff that's involved with trying to get a laboratory up and running.
Hi, I'm Kristen Nichols. I'm the editor of Hemp Industry Daily. So I say I don't really do anything. I just talk to interesting people like these that do. And covered this before I covered cannabis full time. I covered state legislatures in a lot of different states and regulators. So kind of from that end too.
Hi, and I'm Jake Black, co-founder at Treehouse. We started out in 2015, and similar story to Kyle. Started with small scale lab and have scaled it to a more production scale facility for hemp derived ingredients. And I've been functioning as the CEO there for the last few years, and so I've been involved in all sorts of dietary. We were one of the first dietary supplement certified GMP manufacturing facilities in the country for CBD. We went through all of that from the ground up and seen a lot of that law. And additionally, I've served as an expert witness in a couple cases, a PhD in chemistry by training. And so I've done some analysis of different yields and purities and compositions in court cases. And so from a legal standpoint, hopefully I have some insight there.
Beautiful. Thank you. As we move into the first calendar year, the DEA no longer considers hemp to be a controlled substance. The regulation of the hemp industry finally moves towards a place of clarity. As banking and production rules and taking shape on a federal level, individual states move to craft plans that will fit their particular localities. Understanding how the states operate is crucial to running a compliant, successful brand. As a legal medical marijuana state with a widespread hemp industry, Midwest regulators are crafting their own way. Between recent decisions to functionality, decriminalize cannabis, alongside executive orders banning smokable hemp and creating registries for CBD sellers, there's a lot to know about operating in the Rocky Mountain region. So let's start with, can somebody please define exactly what the barriers are of the Rocky Mountain region?
Yeah, I'll start off, add a little insight into that. So when it comes to Colorado specifically, in terms of this portion of the Rocky Mountain region, as I'm sure you guys know, it is probably one of the most mature markets in terms of cannabis in the whole United States. As for hemp, I mean, it has the same maturity level as the rest of the United States. So I think it's really interesting that Colorado already has a really strong and mature framework for the regulation of one of the forms of the cannabis plant. And that has allowed them to kind of get ahead in terms of regulating the hemp space. Although we're still definitely a long way off from actually having systematic regulations in terms of getting involved with the production and testing specifically. So if you're, the first thing that you're going to want to do if you're trying to start up a brand, start up a manufacturing facility, a white labeling facility, anything like that, you're going to want to get in touch with your Colorado Department of Public Health and Environment, because they're going to be your initial barrier to entry. They're going to want to make sure that you're not just in some garage somewhere filling tinctures, with your bare hands, things like that. They need to make sure that you're producing these products in a safe, clean environment. And personally speaking, over the course of getting different CDPHE licenses through different companies since 2018, I can tell you that it has gotten substantially more difficult, and their regulations have continued to go up and up and up. And now their requirements are actually pretty hefty in terms of getting your CDPHE license every year and getting it renewed. So I would say that would be the first place that you'd want to start, is with the Colorado Department of Public Health and Environment.
Okay, so earlier today, Nicole, we talked about what is the region, and you actually mentioned the Dakotas. And I was kind of taken aback because I didn't relate that. So could you expand on that?
I would say the census doesn't define a Rocky Mountain region. I was saying, I would consider, although there's different opinions, the Rocky Mountains to be not the West Coast, so not California, Oregon, and Washington, and west of Chicago, west of Kansas City. So kind of anywhere in there, the Dakotas, you could consider, you could even consider Western Kansas and Nebraska. There's not a really, so it's a good way of saying there's no right answer, but there's no really wrong answer either for what is the Rocky Mountain region.
Okay, beautiful. Okay, so we've seen and hear about the Delta. The Delta is the hot topic. Delta 8, Delta 6, Delta 7, Delta 8, Delta 10, Delta 11, and now 12. Jim? The question on the table is, what states, particularly this state, is the stance on those products? Why is the regulation written that way? And what is the intent? With respect to the ban on Delta. With respect to the ban on Delta 8.
Well, with respect, my understanding, it is not banned.
In your mic?
Okay, can you hear me at this point? Okay. There's not a ban at this point, but the question is what is the safety issues that we are dealing with right now. And so the FDA, the question is right now on these other minor cannabinoids are those Schedule I controlled substances? And that is the big question that is going on right now with those. I think the FDA and DEA is coming down that yes, these are Schedule I. There, people are disagreeing, so that is going to be the question that is moving forward. They're not currently regulated, if I'm not mistaken, in Colorado, as such. But the DEA is looking at them as Schedule I.
And I'll jump in a bit there because I've actually served as a consultant on the question of like the chemical similarity between Delta 9, Delta 8, and are they analogs? And so just a bit of context, right? Delta 9 THC is the primary form of THC that everyone thinks of when we think THC. Delta 8, Delta 6, all of these are chemical isomers. It gets pretty technical, but they're considered isomers of that main core structure. With the Farm Bill in 2018, they, inadvertently, I think, created some regulations that could be misinterpreted, and people have taken the stance that CBD and minor cannabinoids were allowed per the Farm Bill. It didn't particularly exclude others. And so if you're taking CBD from hemp and turning it into Delta 8, that is okay or fine. And I'm of the opinion that the DEA would disagree with you because they have a longstanding federal analogs act, and Delta 8 and a lot of these deltas have been listed for decades in the World Health Organization and even on FDA kind of registries as isomers of Delta 9 THC. So I think you're in a, you can argue anything in court, but I wouldn't want to argue in front of the DEA or judges that because of the Farm Bill, the Delta 8 is now okay. So that's, again, I'm not a lawyer, that is an opinion, but from a chemical standpoint, I think most chemists would say, no, that's clearly an analog under the Federal Analogs Act. And so there's a lot of it being sold and purchased in the West or in the whole country. And I wouldn't, frankly, we were not doing that. And, I wouldn't purchase a lot of those products. And then the other factor is the FDA's, when you are synthesizing a compound, the FDA has clear rules for the purity of synthetic compounds. It's not terrible. Like, we all consume compounds that have been synthesized on a daily basis, whether we're aware of it or not. And that's fine, and as long as they're done in a safe way, but they're, for the most part, not being done in a safe way, and there's no enforcement on how they're being synthesized. So you have both an FDA and a DEA question, but that's my 2 cents.
I think here's what's very frustrating for businesses and folks. The FDA or even the DEA, they don't have police. There's not an FDA police. What they do are they write memos. We think this. We think this is how the analog law should be interpreted. We think, and then those memos go to the states, and then the states send them to the counties, and then this is a long way of saying you can see a shop here, have police come and say, you can't sell this is illegal. And you can see a shop 2 counties over selling it and advertising it, and go to I've had businesses say, we asked the sheriff, I have this letter from my DA that says I can sell this, So it's right now it's super spotty. Some say because the Farm Bill specifically talks about any extract from hemp is legal, and I extracted this from hemp and then converted it chemically to something else, it's legal. Others say no, the analog law is pretty clear. It's a synthesized isomer of Delta 9 THC that's clearly contemplated as well. Like you said, I wouldn't want to be in court arguing it, but it hasn't been really settled in court. So until we have some cases that say, I would say there are really smart people on both sides of whether the stuff is legal.
And I'd just like to add, just to give you guys an idea of how complex the current cannabis environment is in general. In Colorado, as of right now, Delta 8 is banned for sale, but Delta 9 is able to be sold, where the weaker form of THC is illegal and the stronger form is legal. That's how complicated, convoluted, and weird that this industry has gotten over the course of the last 12 to 6 months.
Well, I'm going to ask the question then, and I'm going to totally get off my line of questioning because this is such a hot topic, okay? Would you say that the reason it's perceived that way, doesn't make any sense, is because we're playing with the Delta 8 on the hemp side of things by virtue of where theoretically, based on the responders, it should sit on the cannabis side?
Well, from my perspective, I see, and again, I'm not pro or con, I'm not for or against Delta 8. Delta 8 is just a compound, and it's from cannabis, and I love cannabis. I would argue that this whole issue stems from a lack of federal legalization of cannabis itself. Because the reason that Delta 8 is so interesting and popular is for 2 reasons. Reason number 1 is that it is available legally in states where it is not legal to be selling Delta 9 THC. But on the flip side of that, the other reason that it is so popular is because it's so cheap relative to Delta 9 THC. Delta 9 THC is a significantly more expensive commodity in the current market because it's illegal in certain states. Some states have caps on the limits for THC production. They're only issuing 20 licenses and that's it for the whole state. Some states it's free reign. You can get as many licenses as you want so long as you go through the application process. Because at the end of the day, if you look at the market, CBD distillate right now in the United States is somewhere around $200 to $150 per kilo typically. And you're talking about a CBD biomass that is usually in the 5 to 11% range while still being compliant for Delta 9 THC. So if you extrapolate that outward to the future, when you have full cannabis legalization, which is those flowers are in the upwards of, the 15, 20% THC, because there's no arbitrary cap on the amount of cannabinoid that can be present inside of that. The distillate, the THC distillate in 5 to 10 years is going to be cheaper than CBD distillate is today because the flowers themselves produce more of the plant, and the process for making THC distillate versus CBD distillate is the exact same process. So the main reason that Delta 8 has become so popular is due to prohibition of Delta 9 THC.
And I,
Okay. Following on what he's saying, I'm going to give you a little history lesson on this. History of the illegalization of cannabis. We go back to the 1930s. And what happened back then is that cannabis was regulated through taxes. It was the Marijuana Tax Act that made both hemp and marijuana, the male and female plants, illegal. And what happened is that they would force you to declare that you possessed it, and they would tax it. And the minute that you declared that you possessed it, they would arrest you and charge you for possession. But you'd have to pay the tax. Well, what happened is that this moved forward. You had to move to 1969. And there was this person that a few people may know in this industry, a guy named Timothy Leary, who many of you know, who decided that he was going to challenge the Marijuana Tax Act. And so he was arrested for possessing marijuana without paying the tax. And he was convicted. This went all the way up to the Supreme Court. And in Leary versus United States, the Supreme Court declared the Marijuana Tax Act unconstitutional as violative of Fifth Amendment rights. So all of a sudden, marijuana was no longer unlawful. Hemp, marijuana, no longer unlawful. The following year, Congress decided, well, we're going to make it unlawful, and the Controlled Substances Act was enacted. And you notice it's all forms of marijuana, which included hemp, that was made unlawful. Well, we now move forward another 25 years to 1996. California and Arizona decided that they were going to make medicinal marijuana lawful. And they passed initiatives in November of 1996. Well, this caught the attention of the Clinton administration. I smoke but did not inhale. Well, it caught the administration there. And Barry McCaffrey, who was the head of the ONDCP, decided to get together a task force. And in this task force, we had a lot of the agencies. This was including the FDA, the Treasury Department, the Nuclear Regulatory Agency, Health and Human Services. I mean, the whole alphabet soup was involved in this task force. And what they did is they got together, and there was a strategy memo created in December of 1996 of how they were going to destroy state legal marijuana. And that memo is available out there. Actually, it's on my Scrib webpage if you want to see it. You look up Kagan, as in Justice Kagan, who drafted the memo originally for the Clinton administration. KAGAN memo. If you look up on script, you will find it. Well, they move forward with trying to destroy state legal marijuana. As far as I can tell, that strategy memo and this task force is still moving forward. The IRS was supposed to deny all expenditures in there. Section 280E on there. The FDA was supposed to come in and it was supposed to regulate cannabis out of existence. That's part of the strategy that we're dealing with. So now, moving forward with what you're saying, is Delta 8, Delta 9, Delta 10, all that, is that illegal? Well, I mean, we look at the states, and a lot of them are saying no, some are saying yes, and all that. Federal government, cannabis bad. And based upon the task force, cannabis bad. So Delta 8, of course, when the DEA comes forward, FDA or whatever, they're going to say, "Oh no, this is a Schedule 1 controlled substance." I mean, you look at 2014 in the Farm Bill. They said, "Hey, hemp was not going to be a controlled substance anymore." The Alphabet Soup said, "Well, we're not sure that they made cannabis no longer a Schedule 1 or hemp no longer a Schedule 1 controlled substance." Congress came back in 2018 and said, "No, we really meant it." And they're still saying, "Well, I'm not so sure." So that's where we're at in the history lesson. Sorry to take so long.
Beautiful. Thank you. Actually, that was amazing. We always get excited when somebody comes to the table and they have the actual history because it impacts where we are today. So let's hypothetically say that DA gets banned and D8 is no longer something that's available now on the hemp side of things and we can't play with it. Does that present a great big black hole and does that impact our industry? Kyle?
Yeah, so by banning Delta 8, it depends on how the government approaches it. If they ban Delta 8 specifically, then it's going to be Delta 10, Delta 6, Delta 6A, 10A. You can keep playing this game. If they ban all of the THCs, there are going to be companies that will fill that void with non-THC, hemp-derived psychoactive cannabinoids. I guarantee it. It's a $100 million to $1 billion industry right now. I know certain companies that are moving over 1 million vape carts of Delta 8 in a month. This is not something that you can just so easily put back in the bag. It's kind of like starting prohibition all over again. If Delta 8 is banned or all THC is counted in total THC, it'll just be the next cannabinoid that will get you a buzz. And it's just going to be a continual cycle, the same way that they had in the early 2010s with the synthetic cannabinoids coming in from China, like the K2 and Spice and all these weird, naturally occurring cannabinoids that they'd make a new one, the government would ban it, they'd make a chemical modification to it, the government would ban it. They kept playing that game until they made the Analogs Act. That's what prompted the formation of the Analogs Act, was people trying to get around it. And now that you have contradictory language that exists within the Farm Bill and what the DEA says, it's a whole new situation, just like in the late 2010s with the synthetic cannabinoids, where it's just going to be a game of whack-a-mole. They're going to ban one, new one's going to pop up, they're going to ban that one. And realistically, all this is just a symptom of prohibition in the country. And as we get closer and closer to legalization, this game of whack-a-mole is just it's gonna become a moot point once legalization hits, I believe.
Nicole, you've been writing about this obviously for years, the industry, right, as a whole. Do you see patterns?
No, I think he's exactly right. This is all this game of whack-a-mole is an obvious consequence of prohibition and people trying to work around ways. Recently, the U.S. Hemp Authority and the U.S. Hemp Roundtable have said, "Oh, you shouldn't be making any intoxicants from legal hemp. It should be basically soap and rope. We want to really go this route, and that the best way to regulate intoxicants should be we should have some sensible cannabis reform." Hopefully, I think most people in the industry would hope that this confusion, this mess, God forbid, kids start showing up in hospitals, if they, had bad experiences, will prompt some federal action. I'm not sure if it will. I do think the game of whack-a-mole continues, but it's extremely frustrating. And I don't know if Delta 8 is to blame. It was going to be something. Some say at high levels, CBD can feel intoxicating. And for some sensitive groups, kind of depends on your personal response. So anyway, I think it's an obvious consequence of prohibition. It's going to continue until the larger caboodle with THC and other cannabinoids is settled.
And just to add to that, I guess my concern is that the DEA and FDA are, maybe not known for their level-headed and clear, thought-out regulation. And so if the whack-a-mole game continues, I could see us taking a real step backwards when a kid ends up in the hospital, or people, we saw it with vape, how quickly some bad actors can ruin it for everyone. And so I see that as like the worst case of, hey, we tried to do this sensibly, and everyone, there's some bad actors who ruined it for everyone again. And now we are going back to a more prohibition state. And so I mean, that's like a worst case scenario, but I also wouldn't take it off the board if people continue to play the whack-a-mole game with the DEA, because again, they're not the most friendly, level-headed, thought-out people. Don't come for me, DEA.
Jim, from a legal standpoint, okay? And we keep coming back to D8. I don't know, it's the natural evolution of this show because it's such a hot topic. And I was on that debate yesterday on the opposing, absolutely against it side. It's not that I'm against it as a cannabinoid for health and wellness. I am against the allowance of using it on the hemp side by virtue of the cannabis side, because yes, we get into the intoxicants. So, Jim, what are some of the legal liabilities, ramifications of that worst case scenario? We'll go back a year to the vaping issues, and we had suddenly, magically out of nowhere, kids were turning up in hospitals with crystallization happening on the lungs. We all got hysterical and went, you can't, right? Moms were losing their minds. Now we're banning vapes. What does that look like in terms of D8? Because I live in the state of Florida now, and D8 is available on every countertop in every conceivable store environment. And I'm watching 17 and 18-year-old kids walk in the door, buy it, and walk back out. Now they're going to get behind a lethal weapon and drive it down the street.
Well, the clearest one to me from the legal perspective is that you have the plaintiff's bar that is looking that you're selling a substance there, and we're talking about various levels of regulation. Let's assume that that it's being sold lawfully there, but you don't have anything on the labeling about the dangers and all that, which you probably don't. There, the kid goes and gets killed, jumps off the roof, gets behind the wheel, whatever it may be, and this happens probably more than once. Now you have a plaintiff's lawyer going after your business, and probably you personally, that you are putting a product out that's dangerous, and that you are liable for this kid's injuries and parents' injuries because of the kid dying and all these various things. And so you're looking at an extensive amount of liability. Now, we just forgetting about the issue about whether DEA is going to come down on you or not. But there is that basic area of common law liability that everybody who's producing any of these is going to have to experience. Even with cannabis, we had the Safe Streets Alliance that was suing cannabis dispensaries who were selling products, and somebody would get hurt or die or whatever, and they would sue the dispensaries. They would also sue the dispensaries on nuisance theories that they were creating a nuisance in the neighborhood. So it's not just D8 or whatever. We're dealing with kind of all levels of cannabis on this, but definitely in an area that's not regulated, you don't have labeling and all that. Yeah, you're wide open for lawsuits.
And I think another frustrating thing about this industry, or to tell people, is no one can tell you, the best attorney or the best manufacturers, no one can tell you what is your personal risk tolerance. And that is a decision only you can make. Right across the hall, they're talking about psychedelics. How you have a choice. You see this new market opportunity. Do I want to miss out on this new opportunity? Do I want to expose myself to, liability? I would say, if depending on your personal risk tolerance, grow potatoes and sell potato chips, all the way to, be in an illicit market. So that's something really, frankly, at the end of the day, is going to come down to your personal risk tolerance for being in this market.
Since 2014, we've been operating against the U.S. Farm Bill. 2018, we got a revised version of it. 2022, we're going to see a new revised version of it because it gets updated every 4 years with new stuff. We, in the industry, historically have had to shift, pivot, because it's a constantly changing landscape, be it in your local municipality, your state, your federal government, and then internationally, because that now comes into play. We have 20 countries now, I believe, that are now engaged in the CBD industry. I personally proudly just opened India. So my question is, from each of your experiences, in final thoughts before we take questions, what piece of advice do you give anybody coming into the industry as it relates to regulation? Because the most common thing I hear in the pushback is, but everybody else is doing it.
I'll jump in. Yeah, so we've been doing it since 2015, and we've probably been one of the more regulatory conservative companies, and that's been since day one. It's a lot more expensive to be regulatory compliant, to be GMP certified, to file GRAS or new dietary ingredients, fire code compliant. Like, it's more expensive by a long shot, and you have to then compete with this kind of mentality of, well, everyone else is doing it. And we've always viewed it as, the old, if everyone else jumps off a cliff, would you too? And our answer's always been no. So since day one, a product with more than 0.3 THC has never left our facility. We've made synthetic cannabinoids. We're very interested in the research. We've never sold them because we believe that we'd have to go through the new dietary ingredient pathway, which the FDA has out, and that's hundreds of thousands of dollars of toxicology studies, and we weren't in a financial place to do that. But that's been our stance, and we've lost a lot of business to competitors of, hey, they're at this price and you're $100 more per kilogram. Yeah, that's what we do. And so we've made that conscious choice to be as regulatory conservative as possible, in the hopes that when the regulations and the hammers do start falling, that we're able to go to the DEA, FDA, whoever, and say, yep, we've been doing this for years. Here's all our paperwork. We're compliant. You can audit us today. We're ready to go. So that's our stance.
I think a business has two choices. You can be the roach, be the little guy, stay small, stay cottage, sell to your friends and neighbors, and don't try to scale. If you want to sell across jurisdictions, even within a state, certainly if you want to sell across state lines, there's absolutely no choice. You need to hire an attorney, let you know whether you're a compliance consultant, make sure you're doing the test. If you want to be the ingredient that, if there's ever a Coca-Cola with CBD and you want to be the maker of that, you got to go down this 7-figure path. That's the way. Or you can keep selling at a farmer's market and hope I'm not that guy. When these rules come down, there's so many bigger guys that are going to come after before me. I'll have time to make my quiet exit and go back to the whatever business I was in before. So I think that's kind of the decision. You want to make a big investment, lawyer up, no way around it. It's going to be a highly regulated industry. If you're an alcohol manufacturer, you have lots of attorneys to let you know what you can do, and it can change county to county what you can do and when you can sell and how. Or again, I'm making stuff in the basement, selling it to my next door neighbor, and no one's going to come after me because I'm too little. That's your choice.
And for me, I mean, my opinion on what you need to be prepared for changing regulations, you have to make sure that whatever business you're in, you're adaptable, especially in this industry. Yeah. Personally, we were manufacturing Delta 8 over a year ago and selling Delta 8. when the DEA released their IFR in late August, early September, we had to cease production. We didn't have to, as you can tell by this show. There's lots of Delta 8 still being sold, but we're not comfortable. We had our own risk tolerance. Once the DEA said no, we decided to back out. But we had to be adaptable enough to say, all right, D8's done. What are we going to do next? Because if not, you're just going to have to shut your doors on the whim of some regulator who doesn't really understand the science, the chemistry, or this industry in general. So I would say be very careful not to get pigeonholed into, I can do this and this alone. Otherwise, that's a very dangerous game to play.
One of the cases that we litigated, I had the honor of arguing the case in front of now Justice Neil Gorsuch. And I won't get into the details of why we were up there. It was the Feinberg case. But in his written opinion on it, he opens the case by saying, this case owes its genesis to the mixed messages the federal government is sending with regard to the sales of marijuana. That's the problem. What we're talking about in the regulation and all this, there is no clear message there. We have state regulations, and I'll tell you, the Colorado state regulations I'll hold up with being probably the best that we've got out there. But we got a federal overlay. If a client comes to me and says, hey, I want to go into CBD, I want to go into hemp, I want to go into cannabis, whatever it is. My first question to them is, are you sure? It's a mess. Justice Gorsuch says it's mixed messages. And you've got to deal with that. And so, until we can get that straightened out, it's really an area you got to tread very, very carefully. Yeah, GMP is one piece, and you try to follow the regulations when there's regulations, when you can, but the problem is that regulation may conflict with another regulation, depending on whether you're dealing with the state or the federal level. So with that, beware.
Just a teeny vignette. We've been selling CBD since 2015. We cannot, federally, it's a drug and cannot be in food products. In Colorado, it can. And so that's just one example. And to get it into the UK, they finally laid out regulations. Thankfully, honestly, we spent $500,000 to get our novel food application submitted to the UK because they were going to prohibit everything. So it's expensive, and he's right. Things change, and there's conflicts.
The first question I ask anytime somebody comes to me and says they want their own CBD brand, in tequila, I'd say, how much money do you have? In CBD, I say, how adaptive are you? Because if you cannot adapt to change and pivot and shift, you don't belong in this industry. It takes a very strong back. At this point, I'm going to open it up to any questions. Anybody have any questions? Well, yeah.
I think that's CBPHE. I don't think that's Denver. I think that's statewide. Yeah, it's a huge issue. And so I hear all the time about label, right? These labels are bad. Or we tested all these products and found that a huge challenge that people are dealing with every day is also shelf stability. Sometimes things you can test, and even if you know exactly what it was and it went in the bottle, 3 months later when someone opens it and puts it and tests it, is it the same? Things can change depending how they've been stored, And yeah, how do you make every label consistent? I don't have a great answer for that, but there is going to be a ton of pushback. Here's a good example. A lot of people take CBD because they don't want THC. And even if they're assured there's no THC or detectable, if you had to list how much and verify that and be judged on that, there might be things that people would avoid, and they're going to go move to isolate products. I don't know, because that's a huge challenge. I don't know when that takes effect, but there's going to be a lot of pushback from people like you that say we can't comply with this. This is too complicated. You guys hearing about this?
I mean, yeah, two parts. One is we've seen that issue since day one on product consistency, and I almost view it as wine, right? You can grow the same grapes in the same vineyard, but year to year, it's a different product, and that's how everyone knows that. But because cannabinoids are active ingredients, we are of the opinion that a consumer, to get the consistent effect, if like a 0.1% CBG has a huge effect, and then some batch of hemp that you extract doesn't have it, now the consumer gets a different product, that's an issue. And so we see the long term of being isolates combined back together, which is not what a lot of people in the industry want to hear, but I think it's the only way to be consistent in your delivery of active ingredients. And just on the shelf life, again, yeah, we submitted 3 of those recently, about $10,000 per SKU, or per product line. So to get a shelf life study going, to then have the proper label requirements and consistency. But
Yeah.
yeah. Yeah.
So
I
I actually am going to step in and answer this because I moved from here to Florida a year ago, and Florida put in regulations, and you have to be permitted by the state, food and manufacturing. USDA offices come out, they do the inspection, they check your labels. You have to go through this entire process, and it turns out we have several states in which you actually have to present your label in order to distribute into the state. I was denied the state of New York and the state of Louisiana, and I was positive my labels were flawless because we followed the FDA definitions. You've raised a really good point. You're talking about an active organism. If that consumer takes that bottle and for whatever reason sits it out in the kitchen window and it's an 80-degree day, the activity of what's inside that bottle is going to completely change. If it were tested, it would not be consistent. Right, so what we do is we simply say, listen, leave a blank spot, produce a little ancillary sticker and stick it on if that's what has to happen. I mean, we've kind of reached this point of you got to get creative. I often get, we have to trace, batch, and lot everything in the state of Florida now, everything. I was the first to create a CBD specific recall plan because we had a product come back that was very heavy in leads, and I lost my mind. I mean, literally lost my mind. When you start moving down that road, now you're really considering why those labels look the way that they do. But there are so many moving parts to this because, again, you're talking about a scientific live organism in its truest form. We've simply had to get very adaptable. So we don't do runs of labels all at once. You run your labels per your batch. And then you keep consistent logs, consistent records, and run them by the batch. There are printers that will do that for you. There are private label companies that will run small batch for you. Any other questions? Anything you want to add? Awesome. Thank you so much for attending CBD Expo. We're glad that you were part of our panel today. If you have any questions, you want to have one-on-one time, please reach out to any of our amazing panelists. Enjoy the rest of the show.
Thank you, guys.